Right, good morning and welcome to the second in a series of bite-sized webinars discussing counterparty risk. Today's seminar is entitled Guarantees, Do I Have One and When Can I Enforce It? And will be presented by David Pitlarge, a partner in the shipping team, and Charlie Fraser, an associate in the same team. In terms of housekeeping, and in order to keep the quality of the webinar as good as we can do, we've muted all microphones and turned off videos. Could you please keep them muted? That will help a lot. If there are any questions during the course of the webinar, please could you use the text function on the Teams speech bubble thing, which you can find on the toolbar. And at the end of the presentation, I'll direct the questions to either David or Charlie as appropriate. Please be aware that the text function can be read by all participants in the seminar, and we will be recording the presentation. If you have any questions afterwards, of course, you would be very welcome to contact David or Charlie direct. Now I'll hand over to them both, and I hope you enjoy it. Thank you.
Thank you very much, Tony. Thank you for the introduction. Welcome, everybody. Tony used the phrase pint-sized, which I worked into my introduction as well. I took it from the compressed commentaries on a day's cricket from the Ashes last year. So this is a pint-sized, and it involves the same degree of editing of what is a complex subject. We think it's important to look at this in terms of our shipping practice, because although construing guarantees and dealing with the esoterica of the law that arises is not part of our day job, the structures and the security that the guarantee provides are things which commonly affect our ability to recover, or conversely, the liabilities which we might create for other people to recover against our party interests. It's a big ask to try to compress this, but what we're going to look at are what I consider to be the essential features. I'm going to run through these now, and then Charlie's going to take some of the really important points. There are, as with a lot of English contract law, there's a lot of flexibility and tolerance, but there are some rules, and they're important ones. So we'll look at the nature of the guarantee. We'll consider some of those most important formal issues. We'll consider where you can lose the enforceability of your guarantee. We will think about how these, which are contracts, the common features of contracts, and we'll look at one or two specific examples. So, as I say, the importance of the guarantee cannot be underrated. In many ways, its effect is as profound as the limited liability company. It's worth reflecting that the statute which still governs guarantees as such has been on the books for over almost 350 years. So you can see what a central part it is in the evolution of commercial life and commercial law. The idea that I can contract with Charlie, even though she has no money, because Tony will agree to pay, is very helpful, because there might be good reasons for me to contract with Charlie. She might have a presence in a jurisdiction which is unique to her, or she might have particular skills, or her role in a large organisation in, say, chartering ships or trading, again, might be unique to the people within her team. We see these things commonly arising, and any shipping practitioner or any marine practitioner would have encountered them in a number of contexts. And there, just to remind ourselves of the relevance of this, you can see some examples. Salvage and general average, ship sale and purchase contracts, charters, shipbuilding contracts. Of course, clubs will give their own guarantees, and we have to assess how those should be analysed. And then, of course, there's the wider and more common aspects of personal guarantees and corporate guarantees. So, with that introduction over, I'm going to pass over for the difficult and the most important part to Charlie Fraser, one of my colleagues at Hill Dickinson. Charlie.
Hello, everyone. As David says, the importance of guarantees cannot be underestimated, and they're particularly relevant right now in these uncertain financial times. They give comfort to parties, and they ensure that trade continues. So now I'm going to take you through the nature of a guarantee. And there is considerable variety in the types of guarantees into which parties may enter. They may be very narrow, relating to a particular defined obligation, or they may be very wide, covering any present and future obligations whatsoever or howsoever arising. So let's have a look at different types of guarantee. Now, the first type is a see to it. This is where the guarantor promises to see to it that the principal will fulfill its obligations to the beneficiary under the primary obligation. The second type is on demand. Now, the obligation of the guarantor does not arise until the demand has been made on him. And this is similar in some ways and can be also referred to as a performance bond. Now, the guarantee may be limited, and it could be limited to a particular time duration, or it could be continuing, which will extend to a series of transactions. And this type of guarantee is particularly useful for things such as overdraft or covering subsequent advances. So the big question is, what's the difference between a guarantee or an indemnity? And are they in fact the same thing? Well, the answer is definitely no. Although a guarantee is a promise to ensure that a third party fulfills its obligations and or a promise to fulfill those obligations, which sounds similar to an indemnity, which is an obligation imposed by operation of law or contract on one person to make good a loss of another, they actually have some large differences. And I'll take you through those now. So when we look at the formality of a guarantee, as David said, this comes under the statute of frauds, and it must be in writing or evidenced in writing, and signed by the guarantor or its agent. Whereas for an indemnity, there are no formal requirements at all. The liability for a guarantee is a secondary liability. And what this means in practice is if the underlying transaction is set aside for any reason, or the principal is discharged from liability, then the guarantor's obligations are also unenforceable or discharged. This is different to an indemnity, which is a primary, independent and autonomous liability. If the underlying transaction is set aside for any reason in an indemnity, then it's very unlikely that they will be discharged from liability and the indemnity will remain valid. In the same way, the extent of liability for a guarantee, that is limited to the same extent as the principal is liable to the beneficiary. Whereas for an indemnity, the liability may even exceed the principal's liability because it's a primary obligation. Another difference is the effective variation of the underlying contract. Now, variation of guaranteed obligations may discharge the guarantee unless it has the consent of the guarantor or the variation is insubstantial. Variation of a guaranteed obligation will not generally discharge the indemnity. So those are some key differences. But the question is, well, is this a real issue? Does this actually come up in cases? And it does. The courts are sometimes called on to determine whether on a true construction, a particular instrument is a guarantee or an indemnity. And this case, which I have on screen, demonstrates this. Now, the case concerned the contract for sale of machinery for a cashmere processing plant. The price was to be paid in instalments, and the contract provided for a document described as a guarantee. And you can see there the wording from the guarantee. I won't bore you by reading that out. Now, the reason why in this case it was so important to determine the nature of the contract was that the guarantor argued that its obligations as guarantor had been discharged by material variations in the underlying contract to sale without its consent. And if we go back to the previous slide, as we just discussed, the effective variation of an underlying contract on a guarantee discharges the guarantor's obligations. If it was found to be an indemnity, that would not normally discharge the obligations. The argument succeeded in the Court of First Instance, and this was upheld by the Court of Appeal, who held that it was a guarantee. And the important parts were the wording, if not paid when the same becomes due, which amounted to a secondary obligation, which was reinforced by the sentence, the full and timely performance and observance by the buyer of all terms and conditions. So the court looked at the wording in the guarantee to determine whether it was actually a guarantee or whether it was an indemnity, in order to decide what effect that would have on the parties. So as we discussed already, a guarantee must be in writing or evidenced in writing. It must be signed by the guarantor or its agent, whereas for an indemnity, there are no such formal requirements. Now, the purpose of the 1677 Act was to protect people from being held liable on informal communications. However, the days when this act first came into effect, people were writing in quill pens and times have changed considerably. In particular, modern technology can complicate the issue of what constitutes a signature. And I'm going to take you through some of the case law to give you some examples to show how easy it actually is to have a guarantee now. So the first case is the Maria D. Now, in this case, there were negotiations for a charter party, which were conducted by telephone and telex between the brokers. The terms agreed included a guarantee by the charterer's broker of the charterer's liability for demurrage. The front page of the charter party was stamped, and it was signed for by the owner as principals, but it was stamped and signed for by the charterer's broker with the words "for and on behalf of charterers as brokers only." Now, the succeeding pages all bore the stamp and signature of charterers brokers, without any indication they were signing only as the charterers brokers. Therefore, the page which contained the guarantee just was signed by charterers as was. So after the voyage, owners claimed for demurrage. Naturally, charterers did not pay, so owners brought an action against the charterers brokers under the guarantee. Charterers brokers admitted that there was a guarantee, but they said it wasn't enforceable because it didn't meet the standards under the Statute of Frauds Act. The Court of Appeal, despite the first page of the charter party stating it was for and on behalf of charterers as brokers only, they held that all formalities had been complied with. Now, the second case is the case in which Mehta was a director of a company, and he offered a personal guarantee to pay the debt of his company to the company's creditor solicitors. This was accepted. However, the email containing the guarantee was sent by a member of staff. It was not sent by him directly. It was not signed by him. It didn't contain his name nor his initials anywhere in the body of the email. However, his email address was automatically included in the email header. Now, he said, when he naturally didn't pay under his obligations, his view was that the email was not compliant with the Statute of Frauds Act as he hadn't signed it. And the Court of Appeal agreed with this. They said the automatic inclusion of the sender's email address after the document had been transmitted was not enough to be sufficient for a signature for the purpose of Section 4. Now, we're going to compare this to a later case in which that is slightly perhaps different. So in Golden Ocean, again, another example of negotiations of the charter party between the brokers. Now, in these negotiations, they proceeded on the basis that charterers would be fully guaranteed, but there was no formal signed charter party ever drawn up. There was just lots of different emails, and the final email was signed simply by one of the brokers as Guy. So the case has two issues. The first, whether a guarantee has to all be in one document, and the second, whether the signing offered as an email as Guy was sufficient for the signature requirement. And the Court of Appeal held that an exchange of emails was sufficient to satisfy the requirements. Furthermore, the signing of the email just as Guy, that was also sufficient. It indicated that it was sent by the broker, and an electronic signature was sufficient, and a first name, initials, or nickname would suffice. And the last case you'll be pleased to hear that I'm going to run through is WS Tankship. Now, in this case, the claimants claimed payment under refund guarantees in respect of instalments under shipbuilding contracts. The name of the guarantor appeared only in the header of the guarantee, where it had been automatically inserted by the Swift messaging system. So if you compare this to the previous case where the email had only been inserted when the email was sent. However, in this case, it was held that a guarantee issued and sent by the Swift messaging system was sufficient for the purposes of statute of fraud, because by sending the message, it had caused the name to be inserted, and this constituted significant signature for the purpose of the Statute of Frauds Act. And now I'm going to hand back over to David, you'll be pleased to hear.
Thank you very much, Charlie. That was very clear and very helpful. So, as you say, there aren't, like most contracts in under English jurisprudence, it's quite informal, but these are important rules, and that in some ways highlights the distinction between what in the very useful table you call the guarantee and the indemnity, and the distinction between the two. It can be very challenging though, and one of the challenges which I think the courts acknowledge is the inconsistency in the use of the terminologies. We'll see in a minute that guarantee, sometimes performance bonds, which are not a true C-to-it guarantee, are headed guarantee. Indemnity often suggests something different from the primary liability, but the important point is to look at the substance of the document when putting it into one or other of those categories. I pick up on my little piece here, which will be about on-demand guarantees, where we see the law developing to some degree. And central to this, again, is that distinction between the C-to-it guarantee, which Charlie has described so well. That is that, using my Charlie and Tony example, when I call on Tony to pay up, with the C-to-it guarantee, I have to establish Charlie's liability. It would be much more helpful for me, who's putting a lot of money into a project, just to say, you should now pay me. So one of the classic examples of something which is more than a C-to-it guarantee is the on-demand guarantee. So let's look at that. The practicalities, as I say, it involves having to challenge the underlying dispute. The classic line you see in a lot of the cases is it's triggered by a simple demand. A word of warning about that word simple. It's simple in the sense that you don't have to fight the case or show the liability, but you do have to comply, and there are rigours on that. One of the most recent cases, which we'll have a look at, is the Rubicon Vantage, which had quite a complex set of documentation which had to be accompanied with a demand. Also, rules as to timing arise. So in some ways we can see parallels with what we do in the charter party world. Wait for the day of the liability to elapse. We had an unlikely triumph, unlikely in the context of that case in particular, some years ago, where someone called upon a demand at 2 o'clock in the afternoon, knowing it wasn't going to be paid, and we got off what would have otherwise been a slam dunk summary judgment. Similarly, think about some of the parallels with the law of demurrage claims. If the demand has to have certain accompanying documents, then those documents have to go with the demand. So caution on the concept of simple demand. The on-demand guarantee is a very effective financial instrument, and I think it is that. We see it often in the banking world, but it does come into our area as well. And I think it's useful to think of it as a finance type instrument, as I say, rather than an insurance or an indemnity type contract. And I've seen uses, we see them often in shipbuilding projects. We'll look at one, not just from the refund guarantees, often the payment obligation of the buyer, and we'll look at Wuhan logistics in a minute. Charters, as we've seen, and one of the most recent cases touches on that. I've even been involved in big wreck removal provisions where the company, the owners and their club have wanted to make sure that an SPV joint venture project company is going to comply with their obligations to remove the wreck, and that's backed by on-demand security. So it's not just for the banking world, it's a very real consideration in the shipping world. So let's just run through then the evolution, or if you like, the way in which the law on on-demand guarantees has developed, and to see whether they're going to be limited to finance institutions or whether they will now have wider application. And I think what we see is that a coherent position is emerging, coherent with the cases themselves, but also with the English law on the interpretation of contracts. The starting point is Marubeni, which Charlie's described to us. And as Charlie rightly said, that's a good illustration of why the classification of the surety contract, guarantee or otherwise, is important, because there might be vitiating factors. In that case, it was a variation, the variation of a true guarantee, a true guarantee does not have to answer to a principal contract which has been varied. Those rules don't apply with indemnities. And I think the on-demand guarantee we might call a supercharged indemnity. Within Marubeni, there was a presumption developed against classifying a guarantee or a contract of suretyship as a true on-demand guarantee or performance bond if the issuer is not a bank or a financial institution. In that case, the Mongolian government wasn't a financial institution and it got out of jail. Moving on from that, you have the so-called Paget presumption. If you read these cases, you are no one and your case is nothing if you don't have a presumption named after you. We'll see in Wuhan Logistics that Paget has been adopted. It was adopted in an earlier case, Gold Coast, by the Court of Appeal, and it stands. That's a different kind of presumption. It's a presumption in favour of the guarantee being a true on-demand guarantee if you satisfy certain criteria. And those criteria are set out there, and they form the basis of the analysis in the recent cases. And they're quite unremarkable in what you would expect. International trade, parties in different jurisdictions, issued by a bank, well, that's being stretched, and we'll look at that in a minute. And that's the area I think we'll see the law developing. Payable on demand, I think that goes without saying. And there should be no exclusion or limitation of the guarantor's defences. Now that's the point I'll come back to in just a second. The sort of term we have in mind is those maintaining that the guarantor will remain liable, notwithstanding the variation in the underlying contract. Now, those are very common terms. So on that basis, the exclusion of them might always take contracts out of Paget. But I think there's flexibility in that. Let's see. So armed with those presumptions, we go forward into the beyond 2010. The first case often cited now is Wuhan Logistics. Wuhan was not as well known to people when this came out as it is today. It was, although it's all about shipbuilding, the actual guarantee was given by the buyer. The buyer was, the buyer's bank was undertaking to pay any instalments which the buyer failed to pay to the yard. There were disputes about that. There was a claim. The yard, the seller, said that the Greek bank's letter of, which was actually called a guarantee, was a performance bond. It should be payable on demand, and the Court of Appeal, in a tremendously concise judgment, very clear, Lord Justice Tomlinson suggested that and Lord Justice Longmore as well, made the fairly obvious point that you should be, while these presumptions apply, you have to look at the words. And doing a balancing exercise, they came to the view that weighing up the factors, it was an on-demand guarantee. And in doing so, they eschewed the idea that you do it as sort of like a football scoring. I think there was 6-4, and they said you can't just do it. It's a holistic process like any other contract interpretation. Moving on quickly then. Consistent with that, our very own Mr. Justice Tier, the Admiralty judgment, had to consider similar issues in 2015 in Caterpillar and Mutual Benefits Assurance. Again, there were issues about that involved Caterpillar agreeing to deliver power plants in Liberia. The performance bond was in respect of some subcontractors' obligation to provide services, which Caterpillar was going to provide advance payment for. It made the advance payments. Performance didn't follow, and Caterpillar claimed under the performance bond on-demand guarantee. The same arguments came up, one of which was MBA, Mutual Benefits, said that they were not a financial institution. Again, they took points on including that term I mentioned about the exclusion of the guarantor's liabilities in certain cases, guarantor's defences in certain cases. And the judge firstly found that Mutual Benefits was a financial institution. This Paget principles weren't limited to banks. And secondly, when applying the Paget principles, that fourth point about the guarantor's defences, he felt was not an overwhelming factor. Most recently, we see the Rubicon Vantage. That was a bareboat charter for an FSO. The key point here, I think, was that in what was quite a complex hybrid guarantee, the first 3 million seems to be like an on-demand guarantee, subject to it being given by a parent company. The balance, I think, even the claimant would accept was going to be more like a see-to-it guarantee in Charlie's distinction. To cut a long story short, the court was not minded, once it concluded that the words were clear, that the first 3 million was given as an on-demand guarantee or a performance bond. The fact that it wasn't given by a bank was irrelevant. So that deals with the Marubeni presumption, saying that once the words tell you otherwise, or it's agreed, and there's a hint of agreement in the judgment, then the Marubeni presumption is spent. So pausing there, what we have is a set of cases telling us what we always knew. You should look at the words first. The presumptions are helpful, but they can be displaced. See what they did with Marubeni and Rubicon Advantage. And even those presumptions have flexibility within them. See, for example, how Mr. Justice Tier dealt with the fourth and actually most difficult criterion of Paget. Difficult because it's always in the guarantees. And you might be thinking, you might be minded to give up once you read your guarantee if you see the exclusion of the guarantor's defences. So let's move on quickly. A question arises as to P&I Club letters. I gave an extended version, if you can contemplate such a thing, to a P&I Club some time ago, and the director there at the end of it, he said to his team, the one thing you should take away from this is never give a P&I Club letter in on-demand terms. One of the reasons he said that is in the 2005 case, the court recognised that there's no reason why a club could not give a performance bond or on-demand guarantee. And think of how that might work. That would mean that the cargo interest, the charterer, can just go to the club and say, now pay, leaving out all of the disputes. If you look at forms like ASG 9, they're not structured that way, they never are. But if you find yourself having to contemplate or give an ad hoc guarantee, particularly when you see the drift towards a slightly more sort of purposive or construction-based approach, free from presumptions, be careful not to fall into that trap. To close, just a couple of observations. A theme in this is that whatever type of instrument we're talking, a true see-to-it guarantee or a performance bonds demand guarantee, these are contracts and the same rules apply. There are rules of construction. We can see that with the cases we've just looked at. We can see that all of that case law that comes from the Supreme Court in the last 15 years will apply to those terms. Consideration might be a factor with a contract of guarantee, less so probably with an indemnity. A way around that, if you think it's an issue, could be to make it a deed. Authority and competence can matter. There was a string of cases with refund guarantees. Beth Bradley is our shipbuilding expert, but going back, say, 10, 15 years ago, the SAFE approvals and certification were an important component in the shipping meltdown, which matched the 2008 crash. We had a lot of people saying that the guarantees given for charter obligations were ultra vires and given by people without authority and competence. So something to check. The last point for now, and then I will leave it there, is law and jurisdiction. These are important points. We are talking on any view with a separate contract, and in an ideal world, it should have its own law and jurisdiction, or the position should be clear. Now, that's particularly so if you reflect upon the relative informality of some of the contract wordings and how they arise. And again, go back to Charlie's talk and some of the contexts. And there's some examples there in the next slide you can see. The first one is from the Golden Ocean case, the one in which the word guy represented a statute of frauds memorandum. I particularly like that one, actually, because the charterer was called trustworth in a case where it wasn't deemed likely to pay and had to be guaranteed. But in all of these cases, these short form words are interposed into charters, and there is no extravagant document running to many pages drafted by a banking lawyer or even with law and jurisdiction terms. Often these are ad hoc when they're fixed. Sometimes they might be inserted later, but you do have to think about law and jurisdiction. Now, in certain cases, the court can be prepared to treat the guarantor as bound by the English law provision and the relevant jurisdiction arbitration agreement. But don't take it as a given, because if you can't get there by construing the document, you then have to go back to the basic principles, both under the Rome I Convention, as we now enforce it, and what is now recast Brussels. And certainly if you go for recast Brussels, you could come up with a different answer than the one if you apply the English canons of construction. So the short point is to make it clear, and I think that was a view indulged by another legend in the field of shipping law, Lord Clark, he was in the Court of Appeal then, in Mora and AXA. That was a case which, and if you look at the standard GA bonds and securities, you'll see that there is no law and jurisdiction provision. The argument there was that as the adjustment was going to be prepared by Richards Hobb in London, that was the place of performance, so jurisdiction could be founded on that basis. But the court denied English jurisdiction there. So again, the very short and practical point is, don't assume that because your principal contract has your chosen law and your favoured forum, arbitration, jurisdiction, that it necessarily feeds into the guarantee. I think I've overshot by 5 minutes, but that's still a record for me in terms of concision. Thank you very much indeed, and we'll take any questions.
Great. Well, thank you to David and Charlie for a very good presentation. And then I see there's no questions have been sent to us during the course of the presentation. So if you do have any additional questions, please feel feel free to contact David and Charlie at any time. It leaves it to me now just to say, please join us next Thursday at the same time for the next thrilling episode, the third presentation in the series, which will be entitled Taking Back Control, Commercial Solutions Through Ship Arrest. And to thank you for joining us today, and hope to see you next week. Thank you very much.